Board. Welcome. I'm Russ Bleemer. I write and edit alternatives to the high cost of litigation for the CPR Institute. You're on the CPR YouTube channel. I want to thank you viewers for joining us on a long holiday weekend. We're back after a long YouTube absence to take a look at a still new U.S. Supreme Court decision. We're recording now in early July. This is the only case in the controversy-filled 2022-23 court term that dealt directly with arbitration. I'm joined in New York City by Phil J. Lurie, Jr. of the Lurie Law Firm. Phil has decades of dealing with complex litigation disputes before federal and state and trial and appellate courts, as well as arbitration panels, particularly in domestic and international arbitration law, reinsurance, insurance, other business and commercial disputes. You can find Phil at www.lurelawfirm.com. That's LOREELAWFIRM.com. Phil and I are joined by our friends in Dallas. Angela Downs is the University of North Texas Dallas College of Law Professor of Practice. She's also the school's Assistant Director of Experiential Education. Angela's a mediator and an arbitrator at JAMS, the nation's largest private ADR provider. And once again, Rick Faulkner, he's a solo practitioner who spends his time litigating, arbitrating, and mediating. This is such a fun holiday thing to do, at least for me. Kick back and figure this all out. I'm so happy you're here. The case, Coinbase versus Bielski. It's a classic arbitration matter. In fact, it's an unusually straightforward issue of lawyer's law. The court has definitively resolved this case in the face of a circuit split. At its core, this is very easy to describe and easy to follow. But at the same time, and this is why we're here, it raises a huge amount, maybe even more than the normal amount, of strategic questions about commercial conflict resolution practice. In one sentence, the court ruled on June 23rd that trial courts must stay the litigation proceedings when a party appeals a denial of arbitration. That's it. That's all it is. The legal media, including CPR Speaks, that's our blog on CPR's website. You'll find that at cpradr.org. We've all labeled this what it is, a clear victory for defendant companies, because they're usually the ones that appeal denials of arbitration. The stay means an instant delay that could go on a long time while backed up federal circuit courts look over the appeals. Now that smacks for a potential of gamesmanship. The Supreme Court was very careful in framing the issue and the decision that such appeals cannot be frivolous, okay? But the ruling opens the door to every denial of arbitration being appealed in deliberately putting the brakes on a matter in pursuit of what's supposed to be a faster and more expeditious arbitration process for the defense. But hang on a minute. Plaintiffs' attorneys are clearly upset that the litigation's halted. Evidence can be lost, memories fade, documents are buried. So it's a big loss for the plaintiffs. But there's potential for gamesmanship on that side too. There's the phenomenon of the so-called mass arbitrations. This is a newish idea. We've discussed it at length on CPR's website, on the CPR Speaks blog. We've discussed it at length with big articles in the pages of alternatives, which you can find at altnewsletter.com. Okay? The idea in mass arbitrations from the plaintiff's view is to bury the defendant companies in demands for arbitration under the mandatory arbitration agreements the companies provide for their employees and for consumers. Got to stop for 1 minute before we get going. The full disclosure, CPR, which produces this YouTube channel and the media I just mentioned, has an affiliate, CPR Dispute Resolution Services, LLC, which provides arbitration rules and services for all sorts of alternative dispute resolution, including mass arbitrations. But anyway, the potential idea for plaintiffs' attorneys, this is something that Bloomberg, by the way, worried about this just over this past weekend. On Saturday, June 29, Bloomberg had an article about this issue. The idea for potential action by plaintiffs' attorneys is that they don't take action. They hold off on their arbitration demands, stack up a whole pile of these arbitration demands, and then request mass individual arbitrations under mandatory contracts. That would trigger this mass arbitration, for lack of a better term, dilemma, which despite the recent sets of rules and processes that have emerged, they push defendants into settlement. So that's a lot. It's a simple holding, but there's a lot here. It's an arbitration case with a clear winner and the winners are as worried as the losers about what happens next. Okay, now is that right, Rick? Is that what's happening here? What do you see going on?
I think it is. I think this is a great win for the defense and for the general proponents of arbitration. We used this exact case in an oral argument on Friday in a court here in Texas, and I assure you the matter will be going up to the Court of Appeals and
Did you cite Coinbase?
Yes, absolutely. Which my opponents had not read, did not know anything about. So, to quote Gomer Pyle, surprise, surprise. The trial judge was very interested in learning what the U.S. Supreme Court had said because she wasn't aware of it either, but she was listening very attentively. Let's talk a little bit about the good parts of this case and then some of the dangers that I don't think were at first apparent. Good part is it's a clear rule. We understand there will be a stay as long as the appeal of a denial of arbitration is non-frivolous. But as the devil is often in the details, what does this do when somebody wants to play games and a party goes to court, as every major arbitration rule set allows, for preservatory or protective relief in the sense of deposits, injunctions to protect trade secrets, to stop unfair, improper competition under a non-competition agreement? Will those matters be stopped by a sudden demand for arbitration that is slow walked by attorneys and parties who really don't want to go to arbitration, but can use the process to effectively monkey wrench otherwise important protections for intellectual property? I mean, I do some of that type of work, and that's a major concern for us because we're looking at this going, wait a second, this can turn out to be a Pyrrhic victory. Additionally, I'm thinking back some years ago with a less than artfully drafted arbitration provision against a client in the bad old days when banks were foreclosing on everything in Texas. We stopped numerous foreclosures because the banks had put mandatory arbitration provisions in their promissory notes, which were picked up and cross-referenced in the mortgage. And we successfully argued to a number of trial courts that, sorry, you can't foreclose on this property because this has to be determined by the arbitrators. And I assure you, the banks were appalled at that outcome. So there's a lot of potential mischief in this, and it's concerning because the court is operating as though Justice Kavanaugh and others believe the propaganda favoring arbitration. I noted that he said asserted, and like you, Russ, I picked up on the asserted benefits of arbitration, supposed efficiency, supposed less expense, and anybody who attends arbitration conferences knows that is a hotly debated topic. I find that it adds an extra $100,000 to a case to go to arbitration rather than federal court. The discovery, that's a toss-up. Some arbitrators will burden us with more discovery and more useless discovery than many courts. With the rules on proportionality now, many federal courts are very careful to make the discovery actually cost effective. And let's face it, arbitrators get paid to read whatever is produced. And just like the clear financial conflict of interest arbitrators have in determining jurisdiction and arbitrability, are these going to be issues as well for discovery? How much of this are we going to be subjected to?
Yeah, I just want to tie that in back to the opinion Rick is referring to for our viewers. Justice Kavanaugh put out 5 points dealing with Bielski, the original plaintiff's argument and the respondent here, and shot them all down. And it seemed, and we were discussing this before we started recording, that none may be more important than his protection of arbitration. He wrote among the 5 points, but on this one, that many, without that stay, and this kind of speaks to those the mortgage foreclosures that you were just talking about. Without the stay, many of the asserted benefits of arbitration, as Rick was just saying, efficiency, less expense, less intrusive discovery, and the like, would be irretrievably lost, even if the Court of Appeals later concluded that the case actually had belonged in arbitration all along. So that seemed to be arguably Kavanaugh's biggest concern and the majority's biggest concern in coming out with this decision.
I agree. And he went on to say that, parties could otherwise be forced to settle. And as you noted, Bloomberg just picked up an article about mass arbitrations that could boomerang on companies. And I typically represent corporations. So I'm looking at this going, wow, this could be a huge problem. And, especially in areas like intellectual property, where the first thing we do is seek a temporary restraining order in order to protect our property and keep it from being placed, on the internet or in the public eye or wherever. There's
no questions. It's weird. With such a clear concern, with such a clear victory, rather, there is a defense concern about what happens next. Now, Professor Downs, speaking of Pyrrhic victories, Justice Jackson wrote a dissent. This is a close call, by the way, for the court. It was 5-4.
Yeah.
Justice Jackson wrote a dissent, and they always call it a strong dissent, and it always is when it's 5-4. But there was some really unusual things in her dissent about the future of arbitration, but more important, the future of how arbitration relates to litigation. It was really a big picture counter argument to counter the big picture argument that Kavanaugh was putting out. You have some thoughts on that?
I absolutely do. And Russ, thank you so much for bringing me into the discussion. One of the things that I found really intriguing about this case is it's one of the first cases that the Supreme Court has heard that deals with the issue of cryptocurrency. We know crypto was, a really hot topic.
The first, the first. Yeah, for sure.
Yeah.
The Coinbase. I mean, if you were on Twitter the past couple of weeks, all the Coinbase stuff, instead of asking us to buy it, was all about this case. It was the first time. It seemed like they were thrilled it was up there, actually.
Yeah. So I think that's one of the things. So this has been a case that folks have been watching. We had business groups who really rallied behind Coinbase in the case, saying that they wanted litigation to go forward because without it, it would impose unnecessary cost. Consumer groups, on the other hand, they were advocating that judges should have the discretion to decide which claims to proceed during the appeal, as courts do in the other areas of the law. And I think it's that thread that the consumer advocates were really pushing that Justice Ketanji Brown Jackson pulled out in her dissent. And I love that she said that the majority opinion really comes out of nowhere, which, I'm not sure how I feel about that particular language, because we know that for the past 2 decades, the court has been very clear about looking at the issue and advocating for the issue of arbitration for all of the ways that we've discussed, being frivolous appeals, efficiency, litigation, and expense, and particularly expense for consumer arbitration cases. It's something that the court has really upheld. But Justice Jackson really was keen on focusing on ensuring that judges still had that discretionary power that they traditionally had, instead of really mandating that cases go automatically to arbitration. So it's something that ensuring that judges still had power that they have in other cases, and it's not just arbitrarily taken away.
Yeah, she was really worried about the third branch's role here in that
Absolutely.
dissent, for sure.
Absolutely. And, and I think a lot of that probably comes from her background. She has been in those courts and made those decisions, and it might be a little bit too close to home for her to see that potential power being wrested away from judges. And so she's wanting to ensure that there's an even playing field with all cases, because one of the concerns with these consumer arbitration cases is that consumers are not going to have the same power that a larger defendant, a plaintiff would. With these cases, it won't be an even playing field. And so I think that's, one of the reasons that she was so concerned in her dissent.
I can't, we can't look at the dissent and leave the discussion of the dissent without mentioning the Supreme Court entertainment factor here as well, because in this case, it was the three liberal justices, Jackson, Sotomayor, and Kagan, but they were joined by Clarence Thomas. And it was really disappointing to a lot of observers that Thomas didn't write an opinion. The assumption would have been his usual dissent in arbitration cases, that the Federal Arbitration Act doesn't belong in state court cases. And I assume that's where he would have gone, but he also didn't join in a lot of the reasoning that went in the dissent.
He joined in some parts. Yeah.
He joined in some parts.
Yeah.
So I do think we should note that. It's a little hard to speculate why, but it would have been interesting to see if he could have had a take, or if any of the other dissenters could have had a take on the power of the judiciary point here. That discretion point I thought was really, really interesting, and that may come back in arbitration cases down the road. Or am I just imagining it?
No, and I think perhaps it's planting the seed to say that this is an issue that will, will be picked up and reviewed in other cases, because that discretion is so critically important for judges.
I do want to say that the seed that she planted was quite direct, and we pointed out in our article, and it's been in other coverage as well. And that is, this is something for Congress to decide, because they have changed the way you litigate a case. They're changing the plain meaning of what a stay is supposed to be in arbitration, and this is something that should go back to Congress. That was the way she ended the opinion. Phil, that's also a bigger picture question for you, putting this in the context of the other arbitration cases. Again, before we started recording, you were talking about the relationship of this to some of the other recent arbitration jurisprudence, and how this sort of refocuses the court again after some of the cases from last year. Do you want to pick up on that?
Yeah, sure. One respect is that, remember from Morgan versus Sundance, the court said you can't make procedural rules that put the finger on the scale for arbitration. The arbitration favoring procedural rules. And as you said, this is a case that's very pro-defendant, and you look at it and you say, well, it seems to be putting the average arbitration proponent at a big procedural advantage. And the court, though, rejected Bielski's argument that was the effect, and claimed that we're just basically treating these interlocutory appeals in arbitration the same way as we do in other contexts. But if you look at that and then look at the bigger picture, I have a lot of questions about that. And the rule, as I always understood it, and I think as the dissent points out, the default rule for whether you're going to have a stay or not it's a discretionary determination based on equitable factors, including probability of success and various other things. And that's usually the situation you face. But what the court did here is and maybe this is why the dissent said that they basically pulled this rule out of nowhere, was that they took what's called the Griggs rule, which is the rule that a district court is divested of jurisdiction over any matters that are involved in the interlocutory or other appeal, and turn that into a rule that in the arbitration context, when you have an interlocutory appeal on arbitrability, means that you just stay everything, even though irrespective of whether it's arbitrability or the merits. Now, look at going back to the other Supreme Court decisions. There's a lot of them. Some of these are going back in the '80s, where they talk about the difference between arbitrability and the merits. First Options did that in the '90s, and I think it was one of the AT&T communication workers case did that back in the '80s, and they're drawing a clear distinction. They said there in some cases you might have an overlap, right? So, in a typical case, let's say it's a contract case, and A versus B, and A says, "Well, I'm not going to pay. You need to pay me." But B says, "No, I'm not going to pay you because the contract doesn't exist that you're claiming." Oh, well, by the way, and in that case, if there's an issue of arbitrability, obviously, you've got it's basically the same issue.
That's great, Phil. I want to remind our viewers that I'll have down right below this screen a link to our CPR Speaks blog, which talks about Kavanaugh's look at the merits versus arbitrability and how he shoots that argument down on behalf of the plaintiffs. We'll link to that, and you will see the Griggs case that Phil's talking about. That is a standard for most any federal court litigator to have to deal with. It's a very well-known case. It's interesting, the application here. So thanks for bringing that up.
You raised a key point, which is federal court litigators. And we know that there is look-through jurisdiction available under the FAA to enforce agreements to arbitrate. But let's think this all the way through. The great majority of arbitration cases end up in the state courts. I sometimes act as Professor Downs' teaching assistant on arbitration and mediation issues, and it's always fun teaching with her at UNT. But, most of the cases, are particularly consumer cases, are too small to ever get in federal court. There's no federal question. And consequently, you have state court judges. Now, the Texas statute and a few others provide that stays are available on the same basis as Section 16 of the FAA. That's what Texas says. And so, yes, there's a great argument that the stays must now be automatic. But what happens if they aren't? It's no secret that many of our state court judges are not friendly to arbitration. There's a lot less support in the business community. Texas just passed a business court law with a business court of appeals, and specifically much of the testimony in the Texas Senate and in the House related to the ridiculous cost of arbitration and why business courts would be a better alternative. So we're going to experiment with those like 30-odd other states. But a lot of cases would end up going to the state courts. Now, it's great if a matter is compelled to arbitration. But let's say that a party says there was never an agreement to arbitrate at all. If they object, a la Kaplan, and then participate, if they win, great. But if they lose after having objected, they get to go back to state court, not federal court, if there's no federal question, no diversity jurisdiction, and try to convince a state court judge there was never an agreement to arbitrate. And they may be successful. This could end up being the exact reverse of what Justice Kavanaugh is attempting to accomplish. And as an arbitrator, I'm all in favor of arbitration most of the time, but I've also been a state judge where I have to look at these things and go, wait a second, that balancing test that Justice Jackson talks about can be critically important, because do you allow a foreclosure? Do you allow issue a temporary restraining order or temporary injunction to protect intellectual property? Those are issues that ordinarily would not get to a federal court. And so we've got a real set of issues here that may be much broader than anyone thinks. And, the Texas Supreme Court has disagreed with the U.S. Supreme Court multiple times on arbitration procedure. And unlike Hall Street, the Texas Supreme Court does not follow that portion of the U.S. Supreme Court jurisprudence. So, you can have some real interesting conflicts here that may not get back to federal court.
So, Rick, you were saying before the boomerang effect would be the mass arbitration in the wake
Yes.
of the appeal, but you're adding another layer of boomeranging here because you're saying they're going to go back to state court regardless. Does this case
Right.
spark that, or is that
I think
just
it does.
so this enhances, because that's an existing problem already that could happen if somebody has the money and the wherewithal to do it. But you think this particular Coinbase versus Bielski decision encourages that even more?
Absolutely. And the gamesmanship is available on both sides. And look, we've got real smart lawyers on the defense side. We've got real smart lawyers on the plaintiff side. And these folks are going to figure out every nuance, every opportunity. A lot of companies now retain specialist arbitration counsel like Phil and I and others. And we spend our time getting into the minutia of these types of decisions, to look at what DRI said, to look at what the American Association for Justice said, the Chamber of Commerce, Professor Berman. There are a number of folks who have spent great amounts of time carefully considering the nuances here. And I can tell you, most state judges love it when we get into these U.S. Supreme Court decisions, particularly where they are somewhat balanced and, emphasizing different things, because that's a whole lot better than the usual run-of-the-mill cases they get in a general court of jurisdiction where they've got criminal, they've got family, they've got lots of they have many things that are not particularly intellectually stimulating or entertaining. I'm trying to be diplomatic. I'm never going to sit as a judge again, but I did not really want to hear my 500th automobile accident case or criminal case, etc.
Rick, thank you for coming.
But Rick, I think your point is very well taken, that the opportunity for gamesmanship to really play the system, it's really ripe. And if parties have the money and the inclination, I think that they will take advantage of this. I truly believe that. So I think that's a very good point.
Rick and Angela, thank you for making this minutia so entertaining on YouTube. Arbitration minutia, who knew? Phil, do you want to sum up and take us home as our time is running short?
Well, I'll give it a shot. I mean, we covered all of the advantages and disadvantages, I think, of this decision and how it's going to be construed in the future. And I would just say that I think if the dissent had the better end of the argument in terms of whether there should be a mandatory stay or not. And I think it's very interesting that you had Justice Thomas joining this dissent, and he joined, I think, everything but the first part. I was looking at it today. It's not 100% clear, why he didn't join that part, but he did get, but the rest of it really was the substance of it, and I suspect he didn't think that that the issue of arbitrability that is the sole subject of the appeal is directly involved in that the merits, I should say, not the arbitrability, but the merits are directly involved in an appeal of arbitrability. So, and again, when you see that, it kind of makes you wonder why the majority went out of its way to reach this conclusion. And then I guess those of us that are skeptical, or I think most of us are, see that as as a very pro-arbitration decision, and perhaps one where I think the thumb really was put on the proverbial scale in favor of arbitration. Even though maybe the court didn't have in mind the dynamics of mass arbitration.
Rush, you might be muted.
I'm sorry, I was muted. That outlines our assignment going forward. Thank you for reminding me to unmute. That gives us our assignment going forward, is to watch the district courts and see what comes up, whether it be mass arbitrations or the kind of appeals that Rick described in the wake of this case. The Coinbase citations are going to as easy, as straightforward a decision as it is. The Coinbase citations down the road are going to be very instructive. I said, Phil, please wrap it up, but I see Professor Downs and Rick, we're on the edge, so I'll give you each another 30 seconds. Professor Downs, is there anything else you want to say to conclude?
No, with all of these cases, I think, the story's not over. I really believe that the gamesmanship, as we were just discussing, it's out there, it's ripe for that. So I think we're all going to stay tuned, stay watching. And we're also going to see how this is going to affect our judiciary. I think that's going to be very interesting to look at our state courts and also to monitor to see what's happening on a district court and other levels across the country.
Thank you, Rick.
This is a decision with a simple solution. The problem is it's too simple, and it opens up unintended doors in many ways. And as some of my international friends say, we love arbitration because it's 3 lawsuits in one. Whether you agreed to arbitrate, what you agreed to arbitrate, and after you've arbitrated, whether it was done correctly and with authority or imperium in the international arena. So, lots more litigation on this. It'll take us a while to figure it out. And we're going to have a lot of state courts that may or may not be terribly impressed by the majority decision. And Justice Jackson's decision is very well written. You cannot get odder, concurring counsel than Jackson and Clarence Thomas, but you got them here. And I think that this is going to be a case that produces a lot of litigation over the next decade.
Thank you for doing the impossible on a holiday weekend, making arbitration jurisprudence fun and engaging. I really appreciate it. Looking forward to having you back as the decisions bubble up. Thank you, Professor Downs. Rick, I'm sorry. Go right ahead.
Don't forget, we've got the RICO decision with the unpronounceable Russians fighting over the enforcement of an arbitration award and whether the frustration of that is a proper basis for racketeering and Corrupt Organization Act cases. And that has its own special and fun areas. So it's not the only one. We may be back.
For those of you who don't know what Mr. Faulkner is talking about, I'm going to refer you below to the CPR Speaks blog, because we had an article that we posted last week that said, don't forget about this RICO decision. So there's more on that, but we'll have to take that up as that moves along as well. Professor Downs, Mr. Faulkner, Mr. Lurie, thank you very much for joining. I hope you enjoy the rest of your Independence Day holiday weekend. Thanks for coming on.
Have a great weekend.
Thanks for having us. It's great.
Bye.